You're fed up with waiting 30 minutes for pickup and drop off during your parenting time, where the other parent switches your actual days and times without your notice and or consent. Also, you never hear about school events like basketball, soccer games, band concerts, or parent-teacher conferences, and you know there's got to be a better way. Hello, my name is attorney Danielle Pinkston. I'm owner and founder of Pinkston Law Group, and welcome to What You Should Know Wednesday. Our topic today is parenting plans, pursuant to 750 ILCS 5/60210. So today I will discuss the who, what, where, when, and why of parenting plans in Illinois. Let's begin with the who. Each parent must file a parenting plan in a parental responsibility case, whether it's an actual petition to allocate parental responsibilities or a divorce case. Each parent must file his or her own proposed parenting plan. If you have not filed your parents with the court, then you are not required to file a parenting plan unless the court specifically orders you to do so. However, the courts can and they may look at whether or not you have filed a parenting plan. So rule of thumb is, even if you're not required to file a parenting plan, do so nevertheless. So, the what? What is a parenting plan? A parenting plan is a legal document which establishes the legal rights and obligations of both parents as it relates to their children. Prior to 2016, parenting plans were commonly referred to as custody agreements or parenting agreements. These were the official legal documents establishing child custody arrangements. At minimum, parenting plans must have the following items contained therein. Number one is a section designating which parent or parents will be assigned to significant decision-making responsibilities for the child, including matters related to the children's or the child's education, medical treatment, extracurricular activities, religious upbringing, and choice of daycare or babysitter. Number two, a schedule designating where the child will live and on what days or formula or method for determining such a schedule. Again, one parent can have the child every other weekend, a few days during the week, or parents can have things like one parent has this week, or one parent has 2 weeks on, and the other has the other week or 2 weeks off. Again, it's up to the parents to determine what is in their child's best interest, and hopefully the judge will approve that parenting plan. Number three, a parenting plan must have a section providing that the parties may attend mediation to resolve future issues regarding a change of parental responsibilities or parenting time. This provision is not necessary if only one parent will be assigned all decision-making responsibilities for the children. Keep in mind, sometimes things go wrong. Parenting plans need to be revisited, I would say, every year to make sure things are moving according to what the parents' intentions were when it was entered. However, parents do not always have to run to court and hire lawyers to handle their disputes. They could agree to go to a mediator who is a neutral third party who will hear the facts and hear each parent's desires and needs, and they will try to help these parties or parents make a decision that's best for the child, of course, and also the parents. Number four, parenting plans should have a section providing that each parent has access to the children's mental, dental, psychological records, child care records, school and extracurricular records and activities, reports, and schedules. This would not be required if there's a court order restricting parents from having this information. Again, if you are the parent who has the majority of the time with the children or the child, then it is in the child's best interest that you add the other parent on all records, all lists, at school, at the hospital, after school programs. Because again, the priority is the child's best interest. And it's in any child's best interest to have both parents actively involved in his or her life. Number five, a parenting plan should have a section designating which parent has majority of the parenting time pursuant to 750 ILCS 5/60610. For the purpose of all state and federal statutes that require a designation of and determination of custody or allocation of responsibilities, one parent should be listed as that parent having majority of the parenting time. Now, we'll tell you, I have a case currently in court where the judge felt that because the parties had 50-50 equal time or split time, that one person did not have to be named as that parent having majority of the parenting time. It makes sense, but again, we have the statute on one hand, and on the other hand, we have a judge who, exercises his or her discretion and says that it's not necessary. Number 6, a parenting plan should have a paragraph designating the child's residential address for school enrollment purposes. 7, each parent's home address and telephone number. 8, each parent's employment address and telephone number. 9, a provision that each parent must give 60 days advance written notice if they change their residence. Again, the written notice must include the intended date of the move and the new address. Such notice is required unless it is impracticable or unless a court orders otherwise, and that would be probably in cases of domestic violence and things of that sort. If impracticable, the moving parent must give notice at the earliest date practicable. Keep in mind, if you have majority of the parenting time, you cannot just up and move from where you are if it's more than 25 miles if you're in the 5 counties I listed before. However, you can also not just move outside the state or even the country without first filing notice with the clerk of the circuit court and giving the other parent who is the non-moving parent notice of this. That parent must then either sign the notice and file that with the court, and if they refuse, if they object, then you must file what's called a petition for relocation. Please, before you move, check the statute, call an attorney, make sure that your move will not get you into any type or kind of legal trouble or issues. Number 10, parenting plans must have provisions requiring that each parent notify the other of emergencies, health care, travel plans, or other significant child-related issues. 11, provisions establishing the transportation arrangements relating to the exchange of children for parenting time. Now, what is common sometimes is that parents will either pick up or drop off, okay? Or parents can have a central meeting spot where they meet each other for pickup and drop off time. Or you might have one parent who has a lot of extra time and they will do both pickup and drop off. But again, regardless of what you all decide, that should be in the parenting plan. So there are no surprises. There are no, last minute decisions that the parents can end up bickering or fighting over. Number 12, provisions establishing when and how each parent shall be able to communicate with the children during the other parent's parenting time. 13, provisions for how to resolve issues if a parent wishes to change residences in the future if applicable. 14, a parenting plan should have provisions relating to future modifications of the parenting plan if certain events arise. And number 15, a provision for the exercise of the right of first refusal if desired by both parents. This refers to a parent's right to have the child during the other parent's scheduled parenting time if the other parent is unable to have his or her scheduled parenting time for work or other related reasons. This provision must be set out and must detail or have in detail how the right for first refusal can be invoked, the notice and the response required of both parents in such an event, the transportation requirements, and any other necessary related requirements to protect and promote the child's best interest. This clause or provision can be very important. What this means is, if by chance during your parenting time something arises where you cannot be with the child physically, you might think, well, I'll have my relative, a mother, a brother, a sister, a cousin, or your significant other watch the child. However, if the clause of the right of first refusal is there, before you can do that, you must notify the other parent who does not have parenting time to see if he or she would like to have additional or extra parenting time with the children or the child. Keep that in mind, the right of first refusal. If it is in your parenting plan, you must, of course, notify the other parent who does not have parenting time and allow him or her to make a decision of whether they want extra parenting time or if you can hire your own babysitter or have a relative or your spouse watch the child. And the final provision that I will talk about today, but if you wanted to have additional provisions, you're more than welcome to add it into your parenting plan, would be any other provision that would address the child's best interest or that would facilitate cooperation between both parents. Now, what I like to add into my parenting plans is a provision that says that neither parent will talk about the other parent in a disparaging or negative or derogatory way. We don't want either parent or any parent to badmouth the other person. It is just not in the child's best interest to be forced to choose between mom or dad, or think mom is better than dad or dad is better than mom, or what have you. So again, it may be best to put that provision in the parenting plan so both parents will behave themselves accordingly at all times. So again, another provision that I like to put into parenting plans is the fact that, the other spouse, the parties, spouses, or significant others or relatives should all be made aware of the parenting plan. They should see it, they should read it, they should be made aware of important provisions, and they're all important, so that when the child is around the other spouse or significant other or, relatives, they know how to conduct themselves accordingly. Now, you may be wondering, what if a parent violates a provision that's in the parenting plan? Meaning they refuse you parenting time, they don't add you on to school or medical records, or what have you. If this occurs, then the parent who is a non-violating parent may have the right to file what's called a petition for rule to show cause to have the other person held in civil contempt. Okay? So, we've talked about the what, which is parenting plan. Now let's talk about the where. Where is a parent to file their proposed parenting plan? Well, the answer lies in the place where your case actually lies, or where it will lie. Okay, so if it's in Cook County, you want to file your parenting plan under the case and the case caption of that case. If it's in DuPage County, the same thing. Wherever your case is filed, that is where you want to file your proposed parenting plan. Next, you may wonder, when do I file this proposed parenting plan? Whenever I want? Next year? 2 years? Well, the answer is very simple. Parents must file their proposed parenting plan with the court within 120 days of commencing a court case for the allocation of parental responsibilities. Again, whether it's a divorce case or an independent case for allocation of parental responsibilities, you want to file your parenting plan within 120 days of filing or you making your appearance in any action. Why? The last one is why. Why do we have parenting plans? Well, we have parenting plans because we know that sometimes things come up. Things happen that may be out of our control, but again, we want to have something written down on paper so both parents know the game rules. They know how they should conduct themselves. They know what they should not do, and there should be consequences. So once again, we have parenting plans primarily because they are in children's best interest. We want both parents to work towards making sure the child's interest is a priority, okay, for at least the first 18 years of their life. But again, we want to have this parenting plan in place so that nothing takes away from the child being put as a priority for both parents, and also just to keep the drama down, to keep the drama out of the child's life for at least the first 18 years. That's all the time I have for right now. I want to disclaim the fact that What You Should Know Wednesday is never intended to take the place of a one-on-one consultation. If you have questions that have been unanswered, if you still have concerns, or you want to run something by an attorney, I would advise you to schedule a consultation with me or anyone of your choosing at pinklaw.acuityscheduling.com. Again, I can be found at pinklaw.acuityscheduling.com, or you may call my office at 773-770-4771. That's all the time I have for now. Thank you for tuning in, and I will see you next week for What You Should Know Wednesday.